My name is Ananya Mohindra. I'm a fourth-year law student from Jindal Global Law School. I'll be hosting today's event, and we'll shortly begin with the first panel discussion on the topic of foreign law firms in India, opportunities and challenges. I think we'll begin now. Ladies and gentlemen, esteemed guests and legal enthusiasts, welcome to today's discussion on foreign law firms in India, opportunities and challenges. As our globalized world continues to evolve, the presence of foreign law firms in India raises intriguing questions about the legal landscape. Today, we delve into the potential opportunities these firms bring, alongside the challenges they face in navigating India's legal market. Join us as we explore the dynamic intersection of law and globalization. Our panelists for the day will be Mr. Lalit Bhasin, the President, Mr. Lalit Bhasin, a prominent Indian lawyer. Okay, so we'll continue because the audio is working. Mr. Lalit Bhasin, a prominent Indian lawyer, established Bhasin and Company in 1962 and became a prominent figure in the legal profession. He specialized in employment and labor laws, corporate laws, information technology laws, arbitration, and constitutional law. At 33, he became the youngest chairman of Delhi's Bar Council, served as the IBA honorary member, and later became president of the India Pacific Bar Association. We're really thankful to have you here, sir. Moving on, we have Ameya Kunte, sir. Ameya Kunte is a seasoned tax expert, entrepreneur, and a chartered accountant, known for restructuring, corporate tax, and M&A business advisory. He founded Global View Advisors LLP and is a board member for an automotive company and a member of the Chamber of Tax Consultants. Next, we have Amit Kapur, sir. Amit Kapur, a partner with JSA since 2000, has been focusing on infrastructure sector since 1997. He has been consulted by various government bodies, financial institutions, regulators, and corporations. Sir has also assisted the Kelkar Committee on Infrastructure Development. He served as member of Ministry of Law appointed committee to review the Specific Relief Act, which led to the amendment to the law in October 2018. Next, we have Manish Lamba, sir. He serves as the General Counsel at DLF Cyber City Developers Limited. He has also worked with companies like Bharti Airtel and Bharti Realty in the past. He has been on the User Council of the Singapore International Center. He has also been a part of the legal committee of ASSOCHAM, PhD of Chambers of Commerce, FICCI, and the Gurgaon Chambers of Commerce, and the founding member of Sadmaya, a legal think tank. Lastly, we have Sudhir Mishra, sir. Mr. Sudhir Mishra is the founder and managing partner of the full-service law firm Trust Legal, which specializes in telecom law, infrastructure laws, music laws, ADR, health and environmental law. Mr. Mishra has a vast experience in representing clients both in the corporate and litigation side. He regularly appears before the Supreme Court, various high courts, NGT, various statutory bodies such as the SPCBs, CPCB, and the committees of MOEF. We will now begin with the panel discussions. It's over to you, sir.
Thank you. Thank you. Am I audible? Yes. Good morning to everyone, and welcome to this first technical panel in a law and literature festival. And we heard some brilliant exposition in the inaugural session on how literature connects with the law. And in this session, we'll look at some of the commercial aspects. I don't know, I'm sure Bhasin sir will bring some literature angle in how sort of foreign law firms in India are looking at and the opportunities. That's the theme of the panel. We have three panelists here. Mr. Amit Kapur, Mr. Bhasin, you have already heard him. And we also have Mr. Manish Lamba here. You also heard him in the inaugural session. So, gentlemen, thank you. We have about 40 minutes for this panel, and at least next 30 minutes we will have an open dialogue on different aspects around foreign law firms in India. What is the opportunity and what are the challenges? And then last 10 minutes, we can take some questions, time permitting as well. And Bhasin sir, let me sort of begin with you. This is exactly last March, about 12 months back, the announcement was made, and in a way, it's the first anniversary since this announcement was made, where foreign law firms are allowed partially to sort of operate in India. What has happened in the last 12 months? If you could just sort of set the context for everyone here.
I think that was the first wrong step taken by the Bar Council of India in bringing out these regulations, because these regulations till today, as my experience shows, that they are inoperative. They have imposed, you see, a stay order on themselves. The Bar Council, they made a statement that till they consider the wider implications and the representations made by various associations, including the Society of Indian Law Firms, these will not be implemented. And in all practical terms, these are not implemented. They were brought in, I think, due to certain pressures that negotiations with regard to free trade agreement, that is FTA, with United Kingdom were going on. And there was immense pressure from the United Kingdom, the UK government, that legal services should be opened up. So the Bar Council of India, in a very hasty step, you see, had these regulations which obviously could not be implemented. Speaking on behalf of the profession, if I may say, Society of Indian Law Firms, and even the Bar Association of India, we are not opposed to the entry of foreign lawyers in India. We believe that now we are fully prepared to meet any challenge or competition from the foreign law firms, because Indian lawyers and Indian law firms are second to none. And one example, shining example, is sitting on my right, the Mr. Amit Kapur, JSA. He is the managing partner of JSA, one of the topmost law firms, which can compete with any of the best law firms anywhere in the world. Therefore, these steps which have been taken, they have proved to be counterproductive. I told, you see, the chairman of the Bar Council, and also conveyed it to the law minister at that time, Mr. Rijuju, that we are not opposed, therefore bring it in an orderly manner. First you have to amend the Act. Advocates Act has to be amended, because that only permits Indian citizens to practice law in India. I can't comment more on this, because the matter is now sub judice before the Honorable Delhi High Court. A division bench has echoed, you see, the same feelings, the same impression that we have had, that how do you overcome the decision of the Honorable Supreme Court in Balaji's case, where they have reiterated, Supreme Court has reiterated that Indian citizens can practice, foreign lawyers cannot come to India, they cannot practice in the courts, they cannot do any transactional work, any corporate practice. And even with regard to fly in, fly out, the Supreme Court gave directions, you see, to the Bar Council to frame certain rules as to, because fly in, fly out is from Dubai, every second day someone can fly in and then you see fly out, and that entire thing. Therefore some rules and regulations have to be framed. And even with regard to arbitration, where the Madras High Court in Balaji's case itself had given the concession that they can come and appear. Right. But the Supreme Court said there also you have to frame regulations under what circumstances foreign lawyers can appear, you see, as arbitrators and all that. That is where the position stands, and I don't think this panel can contribute significantly for the reason that now the Honorable High Court is seized of the matter, and this very question has been asked by the Honorable Bench: how do you overcome, you see, the Supreme Court judgment?
Sure, sure. Not on a lighter vein, but on a serious vein, Amit ji must be looking at the reciprocity angle over there and how JSA can go and practice in US, UK, if you already are not. Amit ji, your initial comments on this concept, and we understand it's before the High Court and there are various dimensions. You represent one of the top homegrown law firms. How do you see this proposal?
So I think let's understand that from the point of view of what is in it. Would it surprise you to know that Advocates Act that was enacted 63 years ago, 19th of May 61, contemplates reciprocity? It's not a new idea. It's older than me. So given that reality, unfortunately what's happened, and I'm always grateful to Bhasin Saab, he's a role model, he's a father figure to all of us. And he's always been very affectionate and encouraging to people who are mediocre and put them on a higher pedestal, sir. Grateful to you. But I think we have to understand that at the end of the day, what are the two conflicting issues? India today is seen as an economy on the high table. When the world is receding, we are seen as a growth engine. People want to come and invest in India. China plus one strategy, India is a chosen choice for manufacturing. We are being seen as increasingly an opportunity to try and go to the next level of IT. 6G telecom revolution is seeding here. The Jan Dhan IT stack that we have, the JAM Trinity, is seen by the world as a unique example of how to get over the hurdle of physicality of access and reach out to the remotest parts to people. In that situation, when the foreigners want to come and work with us and we want their money, we want their strategy, they want their technology, can you deny somebody who comes into your country to have ability to access advice, which they rely on? But the question is, can you provide them that while tying the hands and feet of your local talent? That's the conflict. It is not today. Bhasin Saab was leading us then as the president of SILF. I remember as a much 13-14 interactions with the Ministry of Commerce on the bilateral negotiations. So this has been discussed since 1230. 12 years down, we are still discussing. We had agreed to a phased plan of opening up. The idea was to reform the rules that govern you and me. Today, we are still strictly prohibited from advertising as a law firm or lawyers. Look at what the Americans and the Europeans are able to do. We have constraints in terms of our partnership. What is the limit on it? Our LLP rules are still unclear. Various things that lawyers can do, cannot do, are constrained by our principles, which everybody from whom we borrowed those rules have given up. Today, partners in law firms are king's counsel or senior counsel. But you can't have a lawyer as a senior counsel sitting in a law firm. With all these constraints, would you open up your market and leave it open for others to pillar? That's the question. Now, why is it that the policymakers since 2012 to 24 have not been able to think that? I don't know. Because I know that from Society of Indian Law Firm, Jyoti, my founder, Mr. Bhasin and several others, Dr. Bhasin and several others, put our heads together, we did research on the models followed by the world, we brought that to them, said open up Indian market, provide Indian lawyers and Indian law firms opportunity to grow, to compete, and then in a phased manner, over 9 years or 12 years, in phases of 3 to 4 years each phase, you invite the firms in. Had that 2012 discussion, and we have the papers by which it was offered in writing with all research. If you had taken 9 years from 2014 and 23, you had opened up with a vibrant market. But then Rip Van Winkle went to sleep. And then one fine morning we woke up with this notification. Somehow the month of March has a very interesting significance. March 2017, Law Commission report came. March 2018, Balaji judgment came. March 2024 we are discussing. In the middle March of last year, the notification. So it's in the month of March where the financial year is closing, something does happen in this whole situation. But the bottom line is, reciprocity has to be on equal terms. As students of law and practitioners of law, Article 14 as a first principle requires competition amongst equals. It does say that you can't put people who are locally present at a disadvantage and then compete. Normally the world in the GATT and the WTO negotiation is looking at a situation where the host country or the market puts restrictions from others to come in. Here is a situation where they're putting restrictions themselves for others to come in. Now that's a very strange thing to do.
Right.
And if you address that one piece, which should have been done from 2014, I think nobody in India, no law firm, no lawyer can say that a foreigner who comes and invests and participates in this economy is not entitled to get the advice and representation that he or she deserves. That's the first principle. No question. But what we are saying is that you can't do it at the cost of the locals. If we are good enough, then we should be able to compete with them on equal terms. People will have preferences, no problem. It will be beneficial for the profession. You know, the practices come from all over the world. Each country has its own unique experiences. They have their approaches to law, finding solutions, negotiating contracts, enforcing. We will all learn from it. And the profession will be better. The transition will always be painful. Some of us will suffer, but that's all right. At the end of the day, that's the test on reciprocity. Are you creating a level playing field and giving an opportunity to a profession which has been hidebound and restricted to blossom to its potential and then compete in the world? And why would you, as the host country and the sovereign, put the locals at a disadvantage and invite others in?
Sure.
That's the only leg which is remaining.
Sure. Sure. Manish, you come from a very large corporate, Indian corporate, but you of course have benefit of all the great minds in India and sometimes the foreign law firms. As an individual, and not the group that you represent, your view on this concept, and then I want to take the audience take also on this concept before we move to the next section. Manish?
It's a privilege to sit with Dr. Bhasin and Amit. While I completely agree with you, what you are saying, and I also agree with the difficulties which you have raised. 25 years ago, I was sitting over here. That was when I first attended a conference on foreign law firms. Somebody was sitting over here. The same conversation, the same trouble. Nothing happened. So basically, we have to live with what we have. And the time is that ultimately this question, if you look at, there are around about, say, I did not prepare well. What I did was on my way, I saw some YouTube videos which are available and you can go for themselves. One of the videos is 10 years ago and Soli Sorabji was speaking on it. And you will realize it's the same conference, same question, same problem, same stay by the authorities, same view taken by... See, if you look at what was happening, Mahatma Gandhi could go and do law in London, practice in South Africa. You can today go and practice in United States of America. If you see any of those people who were at the helm of the affairs, all their children are studying either in London or in US, or they are US returned. Many of us, I know, because we have a group called Sadgamya, and we have around about 2,500 lawyers there. And I see, so most of the things have happened, we have not permitted. We are talking about reciprocity, we are talking about advertising. Which law firm is not advertising? And I need not tell how it is done. How these conferences are there, everything is there. But ultimately we have to come to the conclusion that the time has come. My generation, when I was 25, I thought in the next 2 years, foreign law firms are going to come. So you must have got the hope 1 year ago also. It has just not happened. So somebody needs to, in the legislation, has to decide. So Mr. Arun Jaitley was once asked, "Yaar, why don't you do this?" He was very eager to do it. He says, "Yaar, lawyers bahut opposition karte hain." So therefore, we are the ones, so what happens in many of the cases is कि हम when you, 25 years ago or 30 years ago, when you go to the train, the last compartment of the train used to be unreserved. तो जो आदमी उस कंपार्टमेंट में चढ़ जाता था सबसे पहले कुंडी लगा देता था कि अब और कोई नहीं आएगा, nobody else will come. This is what many of the people who have been at the helm of the affairs, some of them have been doing. Now we have realized, when I joined the profession, after 7 or 9 years, I was working, as I in the last session said, under Mr. Bhasin. He was on the 10th floor and I was on the 2nd floor. Each one of those people working at Vash Associate, who were chartered accountants and lawyers as well, joined either Deloitte, EY or KPMG. So the vast difference that it brought, so even if it is not there, we need to liberalize them. I understand if you require to advertise, please do so, make those changes, create that level playing field. But God's sake, it should not take from 1961 to 2024. It needs to be opened up. If anybody who's going to benefit, today when I deal with a lot of law firms in Singapore, a lot of law firms in London, I'm no longer talking to a Chinese person or a Singaporean or a Britisher. 80% of the people who come here are already Indians. So we are already sitting over there. If you look at the career, so today around about your best of the law schools cannot absorb more than 2,000 students. 5,000 students at least go to London and Canada to do their LLM. So there is a big market, we must open it, we must do all that what is necessary, we must put the might behind it. Ultimately, a whole other generation will also suffer and this will professionalize. I was speaking last night with Dentons. So that's the only example, what have they done? So they have said that they've not taken the route, they've just taken the name, they have spent Link Legal. He says we were not high on technology, we have spent $500,000 just on technology. We are going into trainings, we are providing better facilities, better opportunities, we have started sharing insofar as information, knowledge, precedents are concerned. So probably if India took around about, say it took 2,500 years for India to become a $2.5 trillion economy. Today it will touch around about 4, today, tomorrow, day after, very soon it will be there. This economy in the next 7 to 8 years, maybe 5 years depending upon which side, or 8 years, it will become at least a $8 trillion economy. So therefore the amount of money which was made in 2,500 years will be made just in 5 years. And when I speak to the government, they say the legal system in India, we cannot have a 1961 legal system and become a $10 trillion economy. If we have to, this is the time, this is the profession, these are the Advocates Act which requires a change, and this is considered by even the government and many of the businesses also, it is a stumbling block. We need to do all that what is required in a way in order to get away with the very important issue which Amit has raised, that needs to be taken care, but the time has come now. If we don't do it, we will never be able to do it.
Right. I know Mr. Bhasin wants to
There
react.
has to be a method in madness also. You see, what has been done is a sheer exercise of futility. Yes, no one doubts, you see, that world, it is all globalized now. Therefore, legal professionals also should be familiar with the global developments, contemporaneous developments which are taking place. But our father of nation, our first prime minister and all, they got their education overseas. It does not mean, you see, that the Indian lawyers who have done from the Indian universities, they are not equipped to be good leaders. I think right from the beginning, after independence, there are lawyers who have sacrificed their lucrative practices to join the governments. You see, whether it was the previous government or it is the current government, these lawyers have played a very important, significant role in the development of the country. Earlier we had Mr. Chidambaram, you see Mr. Kapil Sibal, now we have had Mr. Arun Jaitley here, and then Mr. Ravi Shankar Prasad, and all very distinguished lawyers who have got their education essentially in India. Now, where is it you see that the Bar Council has gone wrong? As Amit has rightly pointed out, there has to be first a level playing field. We are talking of bringing foreign lawyers here without liberalizing the profession in India itself. What about the domestic opening? He says which law firm they are not advertising. Well, I can say for my own self, we don't advertise. Similarly, JSA and all those, they don't advertise. We are not even allowed to have a website which will give some complete information about our activities. That is barred by the Bar Council. They say it is advertising. Now, someone sitting in Cape Town, he wants, you see, some lawyer in Kanpur. He doesn't, we don't have those websites here which can give some information. And they, in US, in the electronic media, they advertise that if you want a divorce, come to me, I am a specialist in that. If you have met with an accident, I am the ambulance chaser. Come to me, I will get you, see, the right compensation. And so these issues had to be addressed first, but we are suddenly talking of bringing foreign lawyers. Which foreign law firm will come here due to this uncertainty in their status? They will not come. Denton is one example. I would call it, it is like a backdoor entry, trying to bypass, you see, the regulation, the provisions of the Advocates Act. I'm not talking of the rules because these rules for me are non-existent. But the rules strangely provide, and that is very important, besides reciprocity, that if a foreign lawyer commits a misconduct here, professional misconduct, he will not be tried by the Bar Council of India, which is the regulator for us Indian lawyers, but he will be tried by his home jurisdiction, whether he has committed, you see, a misconduct in India or not. It may be a misconduct in India, but it may not be a misconduct in that jurisdiction. So how do you decide all these things? So no one is doubting and disputing that, yes, bring them in. But as Amit rightly said, follow the Singapore model, which is a very successful model. Have a sequential phased entry. That is where what he referred to 2014. We made an official presentation to the government which was accepted by the government because they made a similar presentation. You see that, yes, Singapore model, phased sequential entry, but the first stage is opening of the legal services in India. So no one has paid any attention to that.
Right.
And we are talking of foreign lawyers.
Right. Thank you, Mr. Bhasin, Amit, and Manish for those very, very fundamental structural comments on this topic. A quick audience poll here. How many of you believe that foreign law firms should be allowed to operate in India? Those who believe yes should raise their hands. Okay. Okay, great.
Your question is a dangerous one.
Okay.
I'll give you two examples.
Sure.
One question in a hearing where a judge asks, तुमने अपनी बीवी को मारना छोड़ दिया. You answer it whichever way you're dead. So the question is, under what circumstances? Obviously we want them to come in. Our economy will grow if they participate and effectively say. The only thing, and I'm glad that Manish talks about the fact that he's talking to the government. Well, why don't you ask them if the Bar Council Act and the rules have to be amended, why don't they amend it? God is not going to descend from heaven. They have to do it in the parliament. I can't, you can't.
No.
We gave in 1st of July a 49-page line-by-line proposed amendment to the Bar Council rules to make it legitimate, consistent with the Balaji judgment, the Advocates Act, and the Law Commission report. What happened to it? It's still lying there in the files, as is the 2014 agreement. You can't say that, yes, we had a conversation, we went to sleep, we've woken up, now it's a new morning. It doesn't work like that. Balaji judgment is still there. Can you wish away Supreme Court? I wish you could, please do.
Right. Amit, point well understood, and currently even the proposal which is stayed did not allow a full-blown sort of entry. Sure. So, just for the benefit of audience here and for a layman like me, could you help us understand what is it that was allowed last year when it was opened up and there was some uncertainty around it? Just for basic, for layman like me. Yes.
I'll go to your approach. Let's do a poll. How many international law firms have come into India? Yeah, 1 year gone? None. So you know what was allowed?
Sure.
That's the answer.
Sure.
By giving a half-baked solution, which exposes those law firms to liabilities and contingent liabilities, with no certainty of business, with no ability to understand whether your balance sheets in US and Australia and New York and England are going to be consolidated and taxed at two places, with no understanding of professional negligence issues, with no ability to understand whether Indian rules will apply overseas or not if the lawyer flies in. How will anybody come in?
Sure.
It's multiple. Yes, and judicial intervention is there. Even I, as a managing partner of a law firm, when we look at the opportunities, we are very happy staying Indian.
Sure.
Because unless I'm sure that the rules of the game are such which will provide a good, steady platform for us to go out, why would I do that? Why would I put the entire profession at risk for my 500, 600 lawyers?
Sure.
And ultimately, it's about that. So I'm much happier working with the foreign lawyers who are all over the world, pull them in to assist our clients, work with them, and find answers.
Sure. Manish, you have an observation?
See, what is happening is, in spite the law, what happens is business continues. And don't take me otherwise, I'm only telling you the truth. So what is happening is that today, most of the cases, if you look at it, Singapore does more arbitration, seated arbitrations of India, and they are thriving on us. We said that we will neither ना बदलेंगे ना बदलने देंगे. जब तक ये नहीं होगा, ना नॉर्मन तेल होगा, ना राधा नाचेगी. अब राधा कहाँ नाच रही है? सिंगापुर में. So ultimately, what is happening is 150 cases. Singapore is becoming rich. I wish them luck. That's good. I also support SIAC. We have it. Ultimately, what happens? If a powerful foreign investor comes, he says, I want Singapore law, I want Singapore seated jurisdiction, I want arbitration there. We never created that situation, and I completely agree. We must create that situation. We must liberalize internally. But if we do not do so, what is happening today? Even to Indian companies, today the judiciary has moved towards that. Even Indian companies can agree to foreign jurisdiction and foreign law. Now, if that has happened, what is happening? I was looking at two businessmen dealing with it, and ultimately there was a clause which was there that we used to fight when I was also in practice and otherwise, कि jurisdiction to India ki hogi. And the businessman says, please put English law. He says, why are you saying that? He says, there is no certainty over here. I don't want my children to fight thereafter. So if we do not change, and if we are not the change makers, and if we do not, if people like Amit, people like Bhasin Saab do not do so, what will happen in the next 10, 20 years? Many of the Indian parties, two Indian companies will have their cases being...
What are we supposed to do?
If you can't do it, nobody else will be able to do it.
Parliament has to do it.
Right, fair point.
Parliament has
I think we would like Manish to declare that we are the parliament. We'll enact the law.
No, fair point.
Declare us as the government. We'll do it right now. We've given the draft rules. They're lying in the shelf.
If it serves that purpose, I declare it here and now.
Very good. Then I declare you the Prime Minister of India. Now do it.
Amit,
Why don't you?
fair point. I
Being
think
childish. I
so
think what we need to understand, this is important because, at the end of the day, the image must not be conveyed that we are opposed to the idea.
Sure.
To the contrary, the fact that we have given a comprehensive set of amendments to the rules to make it consistent with the judgment, the act, and the Law Commission report tells you that it is.
Sure.
But from 1st of July of 23 to today, in March, so then would you please go and talk to them, because we've talked. We've had meetings with them. Nothing is moved.
Sure.
Even though
Sure.
officially law firms are not allowed to come to India, but so far as our cooperation is concerned with the foreign lawyers, that is always there. our Society of Indian Law Firms and Bar Associations of India, we have excellent relations with the American Bar Association, with the European Union, with UK and Japan, Singapore, everywhere. And we work always. So work is not suffering, economy is not suffering. But I don't understand that if foreign lawyers come here, they would take, they would make India the hub of arbitration. How are you sure of that? They may still like to take it back, to their own jurisdictions. They may still say, okay, we'll go to Singapore, or we'll go to LCIA in London, we'll go to ICC in Paris. So, we are not opposed, I think Mr. Lamba is under the impression that we are opposing. We are not opposing. But what steps we as lawyers can take to bring formally, that is function of the Bar Council, and you have seen how chaotic, this has resulted, which is counterproductive, because foreign law firm would not like to come under such circumstances when you have such hastily ill-drafted rules which cannot be implemented by their own admission. They are not implementing it,
Sure.
And with the uncertainty which is there because of now the judicial intervention, the matter is pending before the High Court. Supposing the division bench of the High Court says no law, following Balaji's judgment, Supreme Court judgment, that foreign lawyers cannot practice. So what will be the... We'll cut a sorry figure. Our country will cut a sorry figure. Our government will cut a sorry figure. I'm not bothered about Bar Council of India cutting a sorry figure.
So
Right,
in fact, Bhasin sir will bear me out. The gentleman who is a doyen of the profession, in whose honor we opened this day, we were in deep consultation with Mr. Nariman. Not once, but 3 times.
Sure.
And took his view on board. We consulted with international law firms, took these rule amendments back to the government.
Sure. Sure.
1. Number 2, most important, please remember this is a golden opportunity for India to grow to a different level. And whatever needs to be done must be done. But if you think, by suddenly allowing 50 law firms, 100 law firms from overseas to come to India, you make India an arbitration hub. I think this is a pipe dream which is another level. It won't happen. For that, India has done well. Our Supreme Court has recognized party autonomy. It has recognized 2 Indians agreeing to a foreign law. And therefore, you are giving a choice. What is the choice? You choose the forum you want. If it's a commercial dispute between 2 private parties, the court doesn't say we are coming in the way. But for India to be the choice, it will not be just because 20 people live here.
Sure.
It will be because your systems, your quality of service is competing with them and your costs are better. Your profession is superior.
Right.
And
that's
one
where
more thing, if I
Sir,
may add
sir.
here, just 1 minute, if I may add here. In India, why arbitration has not taken off, and it will not take off, if foreign lawyers come here, it is because we do not have good arbitral institutions. Here we have ad hoc arbitrations, monopolized and cartelized by retired judges and to some extent lawyers. Therefore, unless you have good arbitral institutions in the country, we have a small one in Bombay, MCIA and all that, but there is no other institution here. Therefore, even if foreign lawyers come here, there is no certainty that India will become a hub of arbitration because there are now foreign lawyers. Rather, the risk is that they will take away arbitration from India to their own jurisdictions.
Right. Bhasin sir, out of the suggestions that you've been advocating to make it work, which are the 1 or 2 important suggestions that you think are absolutely necessary for this to happen? You mentioned reciprocity. You mentioned how the disciplinary action, for example, is taken. Any 1 or 2 sort of highlights that you could share?
You see, this question is academic now. We don't know how the court will decide.
Sure.
Now, it is not for me to express my opinion or for Amit or Manish, to say what. It is now what the court will decide.
So, in your personal view, sir, in your personal view, since you've seen
In my
the
personal
life...
view, first liberalize the profession internally, remove all these provisions which are there in the rules, about reciprocity. Now,
Sure.
how do you have reciprocity? With Baker McKenzie having about 150 branches all over the world, what sort of reciprocity you see we can have, which jurisdiction we will have, what reciprocity we can have with the United States, because each state is independent so far as the regularizing the profession is concerned.
Sure.
Even the from one state to another state, you can't practice without, you see, getting permission from there. So these are the issues which have to be gone into, and now these regulations need to be re-looked. And Mr. You see, Amit Kapur and Mr. Jyoti Sagar, Mr. Lakshmi Kumaran, Shardul Shroff, we have all worked on these.
Sure.
We have given our suggestions.
Sure. Sure. Amit, and then I'll come to you. Amit, one point, and again, let us assume that the rules take a shape in a form that is acceptable. I'm sort of asking a conceptual point, and there are two parallels I'm trying to think. Accounting profession was opened up, and then we saw multinational accounting firms coming, and you have a disproportionate high inflow of capital, and that disturbs the competition within India. And beyond a point, you can't fight that capital. Meaning, maybe you will, but many others can't fight that foreign capital. Same thing happened when online retail sort of came up. I'm just trying to draw a parallel. Is that a sort of a point that sort of plays on mind of the Indian firms?
See, long ago when this started, I was quite amused to find that there was a huge campaign running in Tisazari and Patiala House. And there were posters and banners put out where the litigators felt that lawyers from New York and London are going to land up. Now, who's going to land up in Patiala House to run a 138 litigation? Nobody.
Right.
It won't afford, if they did a full year's earning, it won't buy them a ticket back and forth. So a lot of this is misconceived. When you open up for competition, and we've done it across the board, are we today an IT hub? Are we becoming a manufacturing hub? So you have to compete, that's all right. If somebody has greater muscle, we may have greater talent. Today is the time when technocrats have been able to attract capital far more. And if we have good talent and abilities and confidence, I don't see any reason why we have any problem with that. But you can't constrain me, tie my hand behind my back and put a barrier on my leg and then say, now run. That's the only thing. And the reason why I say this, I mean, these law firms, all of the firms, including Baker McKenzie, they're good friends, we work a lot with them. And we respect what they bring to the table. But they also understand, why have they not come into India? When all of these large firms, and that's one that Dr. Bhasin mentioned, there are several others who are there. We work with them across the board. Why have they not made a place out here? Because of the uncertainty. Now, that's a strange way of inviting somebody home. I invite you all over to dinner, and they say, listen, I don't know whether the roof will fall down or not. I'm not sure whether my cook puts poison in the food, but do come by, it'll be a great evening. Who will come? Nobody.
Right.
So I'm saying, for God's sake, if we follow the principle, that the guest is God for me, right? Deva Atati Bhav. If that is the principle, then please lay it out rightly.
Sure.
Don't make it a crown of thorn and a whole terrain of snake and ladder. Our problem is we have not done that. And
Sure.
I am only saying three things. Number one, please consider and take care of the profession. After all, these youngsters are studying there to become lawyers. This profession must offer them opportunity of growth. Please understand, when you're inviting people to partner with you and participate in the economy, they deserve to get the advice they need.
Sure.
You must accept that as a reciprocal reality. And please make sure that we are able to achieve our potential as a country in whatever field. It doesn't have to be that it must only become an arbitration hub or a litigation hub. But we may not. But if as a consequence the economic growth and the growth of the economy as the citizen and the common man and the opportunities go, that's all right. I don't think that is a problem. So we should not get stuck with the idea that unless I'm an arbitration hub, I won't let the global growth come into India.
Sure.
That should be a problem.
Sure. Manish, I'm asking now to wear your hat of a head of legal counsel. You have probably three key expectations. One is the service, the right advice, and third is, of course, the costs as well. So this proposition on the cost piece, what's your perception? Would that sort of help you manage your budgets better? Will it make worse? Any initial reactions?
Okay, I'll just come to the cost part also. And see, what we are saying is that, as I said that 25 years ago when I was sitting on the other side and we were sitting over here, there were judgments, that 1961 Act was also there. If it requires to be amended, then we must do all that is within our power to do so. Glad that representations have been made. So ultimately ball is with the legislature. But if at all we have to push the envelope, we have to do whatever is necessary as we in business do that insofar as bring in changes, rules and things of that nature. We have to do to upgrade, uplift, integrate this profession. And ultimately I feel with the world, and I feel that once it is opened up, like CA firms and like with the Big Four which are there and other things are there, it will only benefit the country and the economy.
Sure.
So therefore, if there needs to be created a level playing field, certainly we are not against. Ultimately, one day I will also be on the other side and practice. But the point is, what I'm not saying that I'm not laying the blame entirely on the government, but for the 25 years in English, there is a phrase, person concerned and concerned person. They are not the same. So ultimately, as Amit very clearly said, that insofar as Tisazari lawyers were protesting. So ultimately, there is enough and more material and debates which are available. We will be able to decipher why it has not happened. Why this has not happened, and we need to put our might behind. We are creating around about, I was told in one of the debates which I saw, there are 1,240 law schools. Right, 75,000 lawyers join the profession every year in the whole of the country. And not more than 2,000 car parks are there in the Delhi High Court. So ultimately so we have to open up, and if we make the cake bigger and if we all do what is necessary, whether we speak on such forums, when we speak to the government, when we do other things, if a level playing field needs to be created, so it should be done. If it needs to be, if advertising is required, so it be. If the Partnership Act needs to change, so it be. So whatever is required. In 1991, I was seeing that was the first time Manmohan Singh wanted to open the profession, and then they came to the conclusion that there would be litigation and things of that nature. I haven't done that, it couldn't happen. 1 year ago, they wanted to do it. They have done a heart-hearted approach. Even the government and whosoever is the stakeholder needs to do all that what is necessary. And ultimately, if the right time to do this was 1991, the best time is now. But if we want to postpone it, so it be. I'm not saying we meaning thereby all those who are the stakeholders, they need to do all that what is necessary. So I'm sure I will do my bit. I have been doing that. Many others have doing that. Bhasin Saab has said that, Amit has said that in 2014 they've gone to the government. Maybe my generation has failed. Hope is with you people. You will do something. So I am only saying that this is what, insofar as costs are concerned, I'll just give you, every day, one or the lawyer finds out, I can name it Babita. She had come from a law firm, that CMS. She was in Singapore, she moved so I was having breakfast with her and I said that what's happening in UK among the last, if your firm was to employ a fresher, what would you pay? In London, they say we are paying 100,000 pounds. That's 1 crore rupees to a fresher. And I said, what happens at the partner level? She says it comes to a new partner is at 160. That's the difference. But in India, the difference would be 20 times, 25 times, 50 times, and sometimes even 100 times. So therefore, we need to look at, so insofar as costs are concerned, Indian law firms have become, you have to pay for the advice. What senior counsels in India charge, no Queen's Counsel in the world can think of it. So that's the kind of money also which is available at the top rung for the selected few. And I'm sure if you want advice of Mr. Bhasin or Amit, it would not come cheap. And no foreign lawyer would be able to compete with that kind of a fees. Sure. But they command that kind of a value.
Sure.
We do not, as long as you add value, price is not a difficulty. Sure.
You see, what is required is mutual cooperation and understanding between the professions across the world. And it is not because of these rules that understanding will come. It is already there. We, every day, that is day in and day out, because there is time difference, you see. That's why I'm talking of night also. So day and night we are in touch, you see, with our counterparts in the US, in Japan, in Singapore. Therefore, there is already a cooperation. Therefore, economic development is not stopped or blocked because foreign lawyers are not coming to India. Whether they come or they don't come, this cooperation will remain. But these, not only half-hearted, these ill-advised steps like this, they are counterproductive. And I want to tell, you see, this audience, that we in the legal profession in this country are not at all opposed, you see, to the entry of foreign lawyers, provided now the court decides which way it will decide, whether the High Court decision will remain or it will again go to Supreme Court. Therefore, in view of all that uncertainty which exists, I think the question at the moment is academic, under what conditions, you see, these foreign law firms should come. That
Sure.
will eventually depend upon the verdict now, which will be given by the courts.
Right. The organizer Vikesh confirmed to me that we can continue up to 12:50. So we have about 10 more minutes. And Bhasin Saab, I do hope I get a literature angle at the end of this session around this whole saga. I'll invite the audience questions as well in a moment. So be ready with your question and a brief question. But Bhasin Saab, just wanted to sort of take this discussion forward more for keeping in mind, India is a large country, diverse country. Within the legal profession, you have the mid-sized firm as well as the individual sort of practitioners. In what form and shape the law firms will come into India, we don't know. Whether they'll come at all, we don't know. But any sort of advice for the young lawyers over here on how to sort of gear up in case we do see such an opportunity in the next maybe 1 year, 5 year, hopefully not 10 years. Any thoughts, sir?
You see, eventually it is the merit of the law firm or the specialization. This is an age of specialization. You have law firms which are specializing in intellectual property. You have law firms which specialize, you see, in taxation. You have law firms which specialize in information technology. And as I said earlier, our Indian law firms, whether they are big or I would not say small, or the emerging law firms, which have lot of talent, they have the resources, they have the knowledge, they are familiar with the developments in technology, they are second to none. Therefore, they need not, you see, look at what will happen if the foreign lawyers come. Just focus on your own work, focus on your specialization, try to improve your own working, because there is always a scope for improvement. And as Mr. Nariman just now said, you see in that recorded speech which we heard, that we all continue to be students, even if we are judges, even if we are lawyers, and whether in-house or you see outside law, we keep on learning. Therefore, focus on, you see, your knowledge enhancement, and don't be bothered about these, you see, apprehensions that foreign lawyers will come, so what will happen to us? Nothing will happen to you. If at all something happens, it will happen to them. They may have to wind up as they have done in so many jurisdictions. In so many jurisdictions, it is on record. Thank you.
Sure. We can take...
If I may
Amit, you want to-
supplement.
sorry.
In fact, there are two things I would add. Foreign law firms coming will be a great opportunity for you, because you learn from practices across civil and common law jurisdictions and Islamic jurisdiction. By the way, we tend to have stereotypic thought about what you see in Islamic countries, but some of the countries are doing superbly. You look at how the Emirates are doing, you see how the growth of climate change, clean tech, IT, all of that is going on there. So there's a huge world out there to learn from. There's no reason why you should not even today seek internships or opportunities of working with them. It is bound to happen. If somebody has been dogmatic in not implementing, it's okay. Unfortunately, it's the nature of the beast. Would it surprise you to know that the matter of reciprocity in the government file dates to 1994, 30 years. Balaji was a lawyers collective, was a writ petition filed in 2009. 95, and a judgment came in 2009. Supreme Court decided 2018, 23 years in the making. So we need to turn that around. And there is no point in some people being Rip Van Winkles, and they are accountable to us as citizens, while we keep beating each other up on each other's chest on it. If these decisions were taken, 30 years is a hell of a long time to implement whatever you need to do, but it's still pending there, and we are still discussing it. So, not 25, 30.
Right. We have a couple of questions. We have time for 2 or 3 questions. Sir, you, and then you, and then you. Yeah, three of you. Yes, very brief question, and please introduce yourself as well, sir. Thank you.
Myself, Advocate Chanjit Singh Badyal, practicing Dwarka and Delhi High Court. My question is, what are we dealing with? Actually, question is, when we are reciprocity already existing with English courts of England, how does our discussion is different from the actually that principle? The next is, what is the methodology? Already foreign firms have got tie-ups with the Indian law firms.
Right.
So many American Canadians. I think the question should be well addressed in a exposed manner.
Right. We'll take the second question as well, and then you panel could address all the points together, and yours will be third. Yes.
My name is Suresh. According to Indian rules, a person has to be physically present in order to notarize a document, and lawyers are not allowed to charge the contingency fees. In many European countries and North American countries, electronic notarization is allowed and contingency fees are permitted. Do you think changing these policies could improve the ease of doing business for both Indian law firms and foreign law firms?
Right. Bhasin Sahab, so the first point on the reciprocity, if you like to address, and the fee part, maybe Amit, you could start with the larger concept on fee.
So far as the first question on reciprocity is concerned, fundamentals of reciprocity are not that they are principles lying in the books, how it is implemented. And the question that the second colleague raised answers your question actually. The fact that you have completely different rules of the game, that a foreign lawyer can actually work with contingency fee, funding of litigation, success fee, work around arrangements, electronic means of communication, notarizing, while we have all those hurdles in the way, it tells you that there's a difference in the way the practice is. Therefore, there's no reciprocity. How can it be reciprocal? It is like saying that you move in a car and I'll walk and there'll be reciprocity in reaching the same destination. It doesn't work. That's the problem. So the rules have to be implementable. And why I'm saying that is, please understand that ultimately it is not about me or Mr. Lamba or Dr. Bhasin. It's about this generation and the future to compete and work in the world and to grow. It's about India as an economy. It's about 140 billion people succeeding. And for that, you definitely need to make sure that whatever services are offered are top-notch and are able to compete with the best in the world. It is completely unheard of that our policies constrain our own selves while inviting others in. That's the only limited point.
Right. Sir, sorry, we don't have time for follow-on. Sorry, really sorry. One last question and then we'll end the panel. Yes, madam.
Hello, sir. So my name is Advocate Sudhir Mishra. I practice in Patiala House Court and High Court. Sir, I have something to say. Like, if I want to go and practice in UK, I have to clear SQI 1 and SQI 2 level. Then only I'm eligible. Otherwise, I can only be treated as paralegal. So why can't we have such systems in place? Like, if any foreign lawyer comes and practice in India, he should also clear an examination. Then only he should be allowed. And so moreover, when directive principles were framed or judicial review, judicial systems were made, we had borrowed from foreign countries like Ireland and USA. So even, sir, if I do some misconduct in foreign country after clearing SQ2, I can be held liable. But if we have a system in place and we borrow something good from them, even we can have such systems here. Thank you, sir.
I think both are important questions. They answer the reciprocity question again. Why don't we have it? The policymakers need to change it. Now, in terms of the reality that you're pointing out, why does Bar Council in their rules say that a foreign lawyer or foreign firm that comes into India, if we find negligence, and I'll give you concrete examples. I'm sure you're familiar with the AI case that happened in the United States, where a lawyer did research on LexisNexis, gave hallucinations, cited 8 judgments that didn't exist, never bothered to look at it. The gentleman was of roughly the same standing as I have, 30 years at the bar, gave it to the court, and today there are at least 7 district courts who issued 10 to 15-page guidelines where lawyers have to sign up an affidavit to affirm that whatever research they are relying on, they have themselves verified the judgments and all the other details. Professional negligence liability, all the top firms, white shoe firms as we call them in England, have suffered cases where they have actually settled for millions of dollars. In India, what Bar Council says is, if we find the problem, we'll send it to them. Is that reciprocal? No. You are the regulator. You are the gatekeeper. You have to protect. What is the professional negligence? A lawyer conducting his profession in a manner which is harmful for his client. So a foreign lawyer will come, do something which is violative of the rights of a citizen, and this guy will hang around wondering, where should he go and what should he do? Reciprocity? No. How can Bar Council outsource? Literally, you have abdicated your own role. You are supposed to regulate the standards of the profession. So that is not the approach. And if they change these things, I'm telling you, we will welcome foreign lawyers and law firms to come. They either ways are coming and working with us. There is no reason why we should stand in the way, but not at the cost of the profession.
And in terms of UK, you mentioned, now I had a one-to-one discussion even with their High Commissioner only 2 months ago. He says we allow Indian lawyers to come and set up their offices and all that. So I say, yes, Your Excellency, you do on paper allow, but no work permits are given. No work permits are given. That is the reciprocity. And in UK, you know, they are facing a negative growth so far as legal profession is concerned. That is why they are so keen, you see, to have some foothold in India. Yes, they are entitled to have, provided, you see, the Parliament amends the Advocates Act and they are able to overcome the Balaji case. Thank you.
Manish, Bhasin Saab, Amit, thank you for expressing your heart and mind and speaking freely. Please give a big round of applause to the wonderful panel. Thank you so much.
Yeah. Yes, sir. Yes, sir. First, I would like to thank all our panelists for the discussion. I request Dhyani sir to present the mementos to our panelists. First, we have Lalit Bhasin sir, Amit Kapur sir, then we have Manish Lamba sir, and then we have Ameya Kunte sir. Thank you so much.